Greetings and welcome to the latest episode of Legal Bites, the official podcast of Cummings and Cummings Law, where we focus on helping businesses and their principals re-domesticate out of volatile legal and tax environments like Maryland to more predictable pro-entrepreneurship, pro-growth jurisdictions. Today, I am dissecting a recent report written by Matthew Vadum for the Epoch Times entitled Maryland Court Strikes Down Nation's First State Tax on Digital Advertising, a topic on which I have reported at great length on earlier editions of Legal Bites. I will then conclude by explaining how Maryland business owners can use Maryland law to their advantage to relocate their existing LLC or corporation out of Maryland or out of another jurisdiction to a new state the right way while keeping their existing federal employer identification number, contracts, bank accounts, credit history, and track record intact. But first, a brief introduction. My name is Professor Chad Daniel Cummings, and I am an attorney and certified public accountant serving clients in matters of business, tax, and commercial law. I am Chief Executive Officer of the multi-state multi-attorney law firm Cummings and Cummings Law. And in addition to my day job, I also teach business and tax law at the university level. I hold 4 degrees, including 2 law degrees, together with a bachelor's degree in accounting and a master's degree in taxation, in addition to 13 professional licenses and certifications covering accounting, tax, audit, financial planning, and of course, the law. My firm website is www.cummings.law. On August 14th, the Maryland Tax Court struck down the state's digital advertising gross receipts tax in 3 separate decisions involving Apple, Google, and Peacock TV. The court reversed the state comptroller's denial of their refund claims and ordered Maryland to return the money with interest. Now, Maryland enacted this highly controversial tax all the way back in 2021, as I have reported in earlier installments of Legal Bites. It was the first of its kind in the country. Rates ran from 2.5% to 10% of gross revenue from digital advertising, and the rate a company paid was determined by its worldwide revenue, which raises serious constitutional questions and due process concerns, rather than solely by its activity in Maryland. Only companies with more than $100 million in annual global revenue were covered under this version of the tax. The state projected roughly $250 million in additional revenue per year. Through July, it had collected about $535 million, which the comptroller's office says has not been spent. That number is surprisingly large, or at least I think it is. The court held that the tax violates the Federal Internet Tax Freedom Act, which bars states from imposing discriminatory taxes on electronic commerce. Now, the reasoning was simple. You don't need to be an attorney to understand the logic. Maryland taxes digital advertising and taxes nothing comparable. The decision noted that no statewide Maryland tax reaches advertising delivered through traditional media, such as billboards, magazines, newspapers, direct mail, broadcast radio, or broadcast television. Congress, the court said, could not have been clearer that internet services are not to be singled out and discriminated against. Now, this was not the tax's first defeat. Oh, no. A federal appeals court had already struck down part of the same law on First Amendment grounds. Governor Larry Hogan vetoed the bill in full when it was passed, and the legislature used legislative veto to override him. 5 years later, the state is now under order to refund everything it took and pay interest. The lesson for business owners is not really about digital advertising. Rather, it is about what a state's legislature reveals when it does something like this. Maryland looked at low-hanging fruit, in this case, a category of commerce that had grown, digital advertising, decided that revenue should belong to Maryland with no logical basis in reality, and wrote a statute that reached only that category. Again, this raises serious constitutional questions. Legislators were told the bill was unlawful. The governor vetoed it on that basis, and the legislature passed it anyway, collected $500 million, and defended it through 5 years of litigation at taxpayer expense, I might add. That is a posture that absolutely hates business. Maryland does not like small and medium-sized business owners. They don't like large business owners either. You know that if you've been following the news. Now, California has repeatedly proposed similar digital advertising taxes, in addition to its highly controversial wealth tax, which is headed to the ballot this November. Washington State enacted a new tax on advertising services online that is now facing its own set of challenges under the same federal statute. This idea is not going to go away anytime soon. Now, Florida and Texas stand in stark contrast to these business-hating states. Neither Florida nor Texas impose a personal income tax, and neither has pursued a levy of this kind, nor are they likely to do so in the future. That is not an accident or simple timing. Rather, it reflects a different philosophical viewpoint about whose money it is. A business cannot litigate its way out of every bad statute. Most small and medium-sized businesses don't have the budget, even if they had the appetite to do so. Apple and Google can, however, spend 5 years and win. Most companies cannot. What most companies can do is leave the state that hates them and relocate to a state that respects small and medium-sized business owners. Now, with this context in mind, redomestication is the lesser-known legal process of transferring a company's legal state of domicile, which is not the same thing as your personal residency, by the way, to a new state without dissolving it, without creating a new entity, and without triggering federal income tax consequences, but only when performed within the strict formalities required by the Federal Internal Revenue Code, applicable Treasury regulations, and the statutory frameworks of both the destination and departing states. When performed by a competent professional, and that phrase, a competent professional, is an important provision. The company retains its existing federal employer identification number, contracts, credit history, and bank accounts. All of that to say there is zero operational or financial disruption, but only if you get it right the first time. That is why it is so important to work with a credentialed professional and save the DIY for home improvement. I have successfully completed redomestications from all 50 states, yes, that includes Maryland, and for limited liability companies, partnerships, Subchapter S entities, and Subchapter C corporations. So if someone is telling you it cannot be done, what they are really telling you is that they do not know how to do it. Now, foreign entity registration, do not allow yourself to become confused. Foreign entity registration is not the same thing as redomestication, because foreign entity registration, also referenced as foreign qualification among myriad other misleading terms, does not change the company's legal domicile. In fact, it does the opposite by keeping the company in the former state indefinitely and merely adding another layer of compliance and tax obligations in the new state, leaving you anchored to that state you thought you were leaving. Now, a traditional merger, which is still not the same thing as redomestication, creates a new distinct entity in the destination state, may and often does require the issuance of a new federal employer identification number, and can trigger serious legal and tax consequences. Finally, dissolution should not enter the conversation at all, because dissolution terminates the company. It is the death penalty for your business. Dissolution is a going out of business maneuver, not a relocation mechanism. Dissolution is often a taxable event, and when performed inadvisedly, can expose the owners of the company to unlimited personal, yes, you heard me right, personal, joint and several liability for the company's liabilities, both known and unknown. That is because the so-called veil of liability protection no longer exists because the company no longer exists. Simple logic. If you think dissolution is a cost-saving mechanism, you are in for a rude awakening. And if you have a so-called professional suggesting dissolution as a relocation stratagem, please seek better advice. Redomestication, when paired with the change of personal residency and that is an important A reduction or outright cessation of business operations in Maryland can reduce or even eliminate state tax exposure there for the entity and its owners. That's not my opinion. That's not my hot take. That is what the Supreme Court of the United States established in precedent decades ago. Now is the time to consider acting before the Maryland legislature considers changes to Maryland law to hinder or even eliminate the possibility of redomestication. If you have questions regarding potentially redomesticating your existing LLC or corporation out of Maryland or out of another state, please use the link in the description or in the bio for more information on this nuanced process and to schedule time for you and I to speak one-on-one about your specific situation. Again, my name is Chad Daniel Cummings of the firm Cummings and Cummings Law, and I hope that you found this information informative. As always, the information in this presentation, like all of my presentations, is necessarily general in nature and is not legal or tax advice, nor should it be construed as such, because that advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my many earlier presentations on these tantalizing and timely topics, please visit my firm website at www.cummings.law, not .com, but .law, to schedule time for a consultation. I look forward to that opportunity to speak and perhaps even work with you very soon.